Ladies and gentlemen, on behalf of PersianLux, it is with great honor and pride for me to present to you the Leveson Inquiry, a world of media without secrets. Now, many of you may ask, what is the Leveson Inquiry? First of all, it is a public, judge-led inquiry to examine the culture, practice, and ethics of the press. The government ordered the inquiry into press standards after it emerged that the News of the World had hacked the phone of murdered schoolgirl Millie Dowler. Recommendations were then made on the future of press regulation. Its terms of reference require it to consider the contacts and the relationships of national newspapers with politicians and the police, and the conduct of each group, as well as the extent to which the policy and regulatory framework has failed, and whether there was a failure to act on previous warnings about media misconduct. Now, what did the Leveson Inquiry actually look at? First of all, it looked at the relationship between the press and the public, including phone hacking and other potentially illegal behavior, and also at the relationships between the press and the police, and the press and the politicians. The inquiry has been asked to make recommendations for a new, more effective policy and regulatory regime for the press, which will support the integrity and independence of the press and media plurality, while encouraging the highest ethical and professional standards. It will undoubtedly make recommendations about the future conduct of politicians and police in relation to the press, and how future concerns about the media should be dealt with by the authorities. The next question is whether the government is bound by Leveson's decision. The clear answer is no. It will be for the government to decide how to take forward any recommendations the report makes, but Prime Minister David Cameron has said that he intends to implement Leveson's recommendations, provided they are not bonkers. Now, why was the inquiry set up in the first place? The Prime Minister actually commissioned the inquiry in July 2011, following allegations of illegal phone hacking at the News of the World, including claims that the voicemail messages of missing teenager Millie Dowler may have been intercepted. The allegations brought to a head a growing tide of complaints from celebrities and politicians that the Sunday tabloid eavesdropped on their calls. In the days before Lord Justice Leveson was named to lead the inquiry, on 13th of July 2011, the News of the World was shut down and the paper's owners, News Corporation, withdrew its bid for total control of satellite broadcaster B-Sky B. What were the recommendations? Leveson made broad and complex recommendations relating to how the press is regulated. Newspapers should continue to be self-regulated, and the government should have no power over what they publish. Furthermore, the body should be independent of current journalists and should not allow serving editors, government members, or MPs to be involved in its functioning. Transparency should be promoted by the body as fair as possible, for instance, the publication of sources used in articles. If the information is within the public domain, then why not? Incentives need to be present in order for other newspapers to join. These incentives could be cases for monetary support for the newspapers that are taken to court in order to defend themselves, and maybe penalties and charges for those who are not members. Additionally, newspapers that fail to join could also face direct regulation by Ofcom. There had to be a new press standards body created by the industry with a new code of conduct. That body should be backed by legislation which would create a means to ensure the regulation was independent and effective. And finally, the arrangement would provide the public with confidence that the complaints would be seriously dealt with and ensure the press are protected from interference. Ladies and gentlemen, take a deep breath as our next slide will start shortly. What were the problems and how are they solved? The main problem is that Leveson, or should I say Lord Justice Leveson, stated that he has a belief of the incapability of the industry in setting up and running a self-regulated project which would sufficiently protect the public There was clearly always danger that the interests of the newspapers could be ranked above that of the public. In order for this problem to be resolved, Lord Justice recommended a mechanism to monitor that the self-regulator is sufficiently independent and effective. This is known as a recognition body. He emphasized the fact that this must be protected by statute. The statute would have to codify a legal duty for the government to provide protection to free press. And now the issues regarding the operation of the arbitration system. Firstly, the cost of dealing with frivolous complaints on the basis that if this was done by an arbitrator, this could be very expensive in comparison to the current complaint system. Also, arbitration is not an appropriate way to deal with defamation and privacy claims at all. Although the general rule is that arbitrations are dealt with in private, there is nothing to prevent a public hearing being held. And now, are they going to be implemented? Prime Minister David Cameron had reportedly promised to implement the recommendations, providing they were not bonkers. But within hours of the report's publication, he said that he was not convinced legislation underpinning self-regulation was right. Mr. Cameron then warned the press the clock is ticking for them to introduce a self-regulation system with the tough power set out by Lord Justice Leveson. That means £1 million fines, proper investigation of complaints, prominent apologies, he said. Deputy Prime Minister Nick Clegg says he backs Leveson, highlighting a clear split within the coalition government. Labour leader Ed Miliband has urged the government to accept the report in its entirety. PersianLux viewers, this is a video of how the general public think of the Leveson inquiry and its effect. And what about the internet and bloggers like me? The inquiry has been specifically into the press, not into the media more generally. Other people publishing on the internet, such as bloggers and tweeters, are not regulated as such, but are covered by laws on issues such as libel and contempt of court. Lord Justice Leveson himself referred to material on the internet as the elephant in the room. However, any publisher could sign up to a new legislation-backed self-regulator that Lord Justice Leveson envisages. How was the inquiry conducted? Witnesses during 8 months of hearings included alleged victims of press intrusion, journalists, newspaper executives and proprietors, police, communication providers, and politicians. They were called to give evidence under oath at the Royal Courts of Justice in central London. Legally, they could have been compelled to attend. In some cases, specific evidence about phone hacking allegations was not heard to avoid prejudicing ongoing criminal investigations. Up to the 30th of June 2012, the last set of published costs, the inquiry had cost £3.9 million. An inquiry spokesman has estimated that the overall cost of the inquiry so far could reach £5.6 million. Boom, 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 boom. Who is the man beneath the wig? Lord Justice, or should I say Sir Brian Leveson, became a barrister in 1970 and a QC 16 years later. He was made a High Court judge in the year 2000 and appointed to the Court of Appeal in 2006. As chairman of the Sentencing Council, a position he still holds, he is responsible for criminal sentencing policy in England and Wales, not Scotland. Lord Justice Leveson led the prosecution case against serial killer Rose West, who was jailed in 1995 for the murder of 10 women and girls, and was also the judge during the 2006 trial following the killing of 10-year-old London schoolboy Damililo Taylor. Confused? What next? Where do we go now? For my bloggers, that is a picture of my confused face. The Leveson inquiry's terms of reference includes a second phase looking at the extent of unlawful or improper conduct within the media. This is due to take place once all legal proceedings are completed. Police are currently carrying out 3 investigations looking into phone hacking, computer hacking, and payments made to public officials by journalists. May 2012, Lord Justice Leveson released a statement questioning the value to be gained from a Part 2. Please do feel free to share your confused faces on my blog. I'm sure we'll all be more than happy to compare confused faces. Anyway, what does the press think? 2 further matters have been floated by the press in relation to the arbitral process, as ways of restricting access to the system in order to reduce the number of complaints. Complainants should be required to have a code breach dealt with by the complaints arm of the regulator before making an arbitration claim. It is difficult to see how there could be any justification for this approach. It is already clear that one of the features of the complaint system must be that complainants should not be received directly until the newspaper's internal complaints procedure has been engaged. The press has sought to argue that excessive numbers of arbitration claims could be discouraged by charging a fee. Well, this fee could be in the region of £200 to £250. Apologies. Finally, Margaret, what about my opinion? The most important one. As a quick summary, as I know most of you have fully understood this inquiry, I believe that Lord Justice Leveson's recommendation for an arbitration system for claims against the press is workable and a practical solution to a problem of access to justice that we all require. If administered properly, such a scheme would save costs for newspapers and would provide quicker and more effective remedies for claimants. It is an essential element of a new self-regulatory regime. And the whole concept in one quote for me is, take a risk to have a reward, take no risk, play it safe. Finally, what does the Prime Minister think? That is a multi-million-pound question. A rash of reports suggested in October that the Prime Minister would reject statutory regulation, no matter how strongly it was recommended by Leveson. In response, a group of 60 alleged hacking victims, including Hugh Grant and Charlotte Church, wrote to Mr. Cameron to urge him to keep an open mind. In a TV interview on the 7th of October, Mr. Cameron said he did not want heavy-handed state intervention in the activities of the press.